Against the background of the Code of Conduct Tribunal judgment on Justice Walter Onnoghen, we get the reaction of a senior advocate of Nigeria, Candide-Johnson. We also look at the road to judgment for Justice Onnoghen, plus our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the show. I am Shola Shuyeli. On Thursday, the Code of Conduct Tribunal ordered that Justice Onnoghen be removed from office as CJN and banned him from holding public office for 10 years. It also ordered that the money in the 5 bank accounts he did not declare should be confiscated. Now, my guest, Candide-Johnson, was called to the Nigerian bar in July 1984. He obtained his LLM degree from the University of London in 1985. He was conferred with the rank of Senior Advocate of Nigeria in September 2003. He's held several positions and was at one time a member of the Legal Practitioners Privileges Committee and the Disciplinary Committee of the Nigerian Bar Association. I began my interview by asking his views on the conviction of Justice Onnoghen.
It's a tragic personal story. For the man and his family, obviously, it's a tragedy. For the country, I think it's a triumph. It's a vindication of law. It's an example to those who administer law and justice in the country, and it tells the people of Nigeria that when error is committed in high places, even the powerful and the mighty will not escape. This is the only way you can entrench confidence in the system of law and justice, if people know that it applies on high and it applies down low.
Against the background of the CCT judgment, are you disappointed with the National Judicial Council on the decision it reached, a decision which was not made public, but which we hear recommended that Justice Onnoghen be compulsorily retired? Some people think that it amounted to a soft landing for him. What do you think?
Disappointment comes from seeing an expectation which you did not anticipate. I'm not surprised at the attitude the Judicial Council has taken. It must be difficult for them to decide to impose a harsh penalty on one of their own, and it must be difficult to recognize when you're in high and privileged office that the law applies to you as it does to any other person on the street. But the Judicial Council has particular structural difficulties. I think that the progress of our democracy has demonstrated this. It was created to immunize judges from interference by the executive. It was meant to ensure independence. Now, independence of the judiciary is very important, but that independence has been guaranteed by self-regulation and confidence that the judges would regulate themselves appropriately. In many of the cases that have come to the public knowledge in the last few years, it is not clear that the Judicial Council has been as effective as the constitutional privilege has been given warrants. In many cases, their decisions have been inconsistent. In many cases, as somebody pointed out to me recently, the powerful and influential and connected have escaped its scrutiny and its condemnation, and those who have no protection have fallen under its hammer. A body with that importance, with such prominence, which is endowed by the Constitution with such significant power and authority, not just legal authority, but moral authority, has it incumbent on itself to act in a way that is open, transparent, accountable. Everything that a body like that does ought to be subject to scrutiny, and it should not be possible to say they behave in one way for one person and in a different way for the other. This sort of behavior, this sort of inconsistency is suggestive of a perversion of the process and is dangerous for the self-regulation which judges enjoy.
Still talking about the NJC, do you agree with those who think that perhaps it's time to rethink the composition of the NJC? If we want to get the best hand, perhaps it's time to include retired judges of integrity in the composition of the NJC, or even consider people from outside the legal profession?
To coin a phrase from the famous Nigerian philosopher Falale Kulakukuti, uniform na cloth, na tailor de soam. It's not the garment that makes a judge, and judges are human beings. It's not a cult, it's not a secret office. What it is an essential public function funded by the public for the use of the public. It must be accountable to the public. Now, The challenge for us in dealing with composition is that if you form a group that comes across as self-serving, introverted, introspective, and self-defensive, then you run the danger that they will lose direction, they will lose their perspective as to the responsibility they owe to the public. And this is not best practices. In England, when they changed Judicial Services Organization, I think it was maybe 5 to 10 years ago, they set up a Judicial Performance Council, which is a model. And if you look at other countries, Canada, United States, these are not headed by judges. The users of a service provided at the public expense are the most important people to whom you must account, not to those who have been privileged by that system. So I'm certain there are retired judges who have the integrity and the ability, and I think they should be represented because it's a unique perspective, because the view of a judge is important to deciding how to deal with a judge. However, I do not think it is appropriate that the body that regulates the judiciary should be composed almost exclusively of judges. I think it's highly inappropriate that the most senior judge in the country can appoint maybe 80% of the members of that body. And I think it's inappropriate that lawyers, who are a major user of the legal services, though they are members of the council, are excluded from disciplining judges. I cannot imagine any other way to characterize that than self-serving, self-defeating, unaccountable.
So who has the responsibility of championing these reforms, or how do you propose that we go about it?
I think that judges should be consulted widely. And this is important because when we speak of judges most often in the public, we speak about the ones who have disgraced themselves. I'm quite confident the majority of judges are not in that position. Many judges joined the judicial service to advance the law and to administer justice without fear, without favor, without affection or ill will. Now, those judges are ill-served by the leadership which is exemplified in this sort of behavior that we've seen punished on the part of Justice Onnoghen today. And I think that a wide consultation in the judiciary will produce insights which are valuable to decide how to regulate the judiciary. For example, modern policies require that judges should use their time efficiently and effectively. It's a remarkable thing that with that sort of international standard, the Judicial Council perpetuates the view that judges must hear cases, list witnesses, and that they model the test for judicial performance on the most inefficient judicial practices which have been set aside by other countries. Rate of disposal of cases is the most effective means of determining the use of public resources in the judiciary. Singapore has a 98% disposal rate, for example. All the countries determine the performance of judges by their rate of disposal. In Nigeria, the performance of judges is determined by the number of cases they've sat, the number of witnesses they heard, the number of judgments they wrote. It shows that those who are administering the regulation of judges are living in a Dickensian time warp. They might as well have been in the time of Charles Dickens, as if they were in 1874. Their ideas about law and judiciary were frozen into their minds, and they haven't changed since then, even though we're in the year 2019.
The decision of the CCT on Justice Onnoghen is one. There's the issue of the NJC recommendation and then his purported resignation. What do you think will happen next? Because all this amounts to different outcomes.
We're very sentimental people, Africans. I think it's in our culture. We tend to be kind. And a lot of my own colleagues say that a harsh treatment of an individual who has been found to desecrate his office may be unkind. Of course, this doesn't pay regard to what another judge has said previously, that a judge who abuses his office is more dangerous than a madman wielding a knife in a marketplace. Because the damages he does, not just to the individuals whose causes he has betrayed, but also to the public whose confidence in the system of justice is so badly degraded that it cannot function as an effective means of regulating the behavior of human beings, which is critical to any orderly and progressive society. So the confusion is only as a result of a variety of sentimental perspectives. The position should be quite clear. It's what judges tell ordinary common accused every day. If you can't do the crime, if you can't do the time, don't do the crime. A judge above others should know that the consequences for breaking the law will be that ineluctably the law will take its course.
Now, the group of like-minded senior advocates of Nigeria, which you belong to, the Justice Reform Project, JRP, in a press statement it recently issued, urged the government and the National Judicial Council, NJC, to sanction other judges whose legitimate earnings do not justify their wealth. How does the group propose that this should be done?
Well, it's clear that from Onnoghen's case that the executive has declaration of assets of all judges. It's also clear with modern technology and the entire regime for controlling money laundering and financing of terrorism that the government has remarkable resources to verify the declarations of every public servant, not just judges. We speak in particular about judges because that is the occasion for this discussion. But they know, therefore, which judge has earned 10 million naira a year and has 200 million in his accounts. Now, it's a classical red flag. It's a classical point at which the onus of proof shifts to the individual. If you have 10 million legitimate earnings and you can't explain where the 190 million came, there is a presumption, difficult to rebut, but it may well be rebutted, of corruption and abuse of office. I think that this is an opportunity for judges who are in that situation to consider whether they want to do other work. They may want at this stage to consider whether they can remain in office with this sort of burden hanging above them. But it's a remarkable thing. Difficult, as I said, a personal tragedy for the individual. But when the government goes after the Chief Justice of Nigeria, the most senior judge in the country, it must be a signal to all judges across the board that acts of corruption, acts of illegality will not escape scrutiny. And if those acts are discovered in scrutiny, they ought to suffer the possible consequences.
The popular cliche is that it takes two to tango. So if the JRP is so concerned about the judges, what about the lawyers, especially the senior advocates among them, who we hear are sometimes the conduit through which some of these monies are passed to the judges? Don't you think it's time to start naming and shaming?
Certainly, I can assure you that the group recognizes its responsibility to speak clearly about lawyers who break the law as about judges. And the fact is that lawyers, including senior advocates, have been exposed, perhaps anecdotally, because we haven't seen the full case against some of them. But of course, we have some who have been convicted and some who are standing trial. I believe that it is an important part of moral regulation to shame, to shun, to avoid. I think that, speaking for myself, I have no problem with identifying a person who I know has committed criminal acts, and I've done so before. Same way, of course, I myself must be subject to scrutiny, as should everybody who's on the Justice Reform Program. If anybody in that group is guilty of misbehavior and it comes to our attention, we will exercise moral suasion over such person, and we would not interfere with the regulation of that person by law. This is very important. I think that you're right. One of the things we tried to do was to make it clear to the public that not all leading lawyers are criminals and purveyors in justice. The fact is that over the years, it has become perhaps mistakenly perceived that the wearing of the rank of senior advocate of Nigeria is purely a license to print money, and that it puts you into the place where you can market and trade in justice. This is most unfortunate. The rank of senior advocate of Nigeria is intended to be a mark of leadership, a brand for moral and professional excellence. If people cannot fulfill that responsibility, they ought not to wear the silk.
Finally, all of these reforms which we've talked about, I imagine that it would require the collaboration of other stakeholders. So are you reaching out? What are the plans going forward?
We've reached out to international foundations. We want to organize a forum by which the intellectual resources that we have organized and analyzed can be put in the public domain, that we can have a discussion. We can find a way where we can formulate a progressive application of those ideas to the improvement of the system of justice in Nigeria. We have tremendous support from lawyers across the field. We have support from people in civil society who aren't even lawyers. So Justice Reform Project is not just a lawyers or senior advocates meeting. It's a meeting of stakeholders across the entire spectrum of legal practice, including consumers and users. Indeed, this morning I was being informed that we have had outreach from corporate organizations who are invested in the integrity of the judicial system but have been ignored in the past because people think it's a game for lawyers. It's not a game for lawyers. It's a public service funded by the public, and is only allowed to operate by the public because it serves them. If it doesn't serve the public have no need for a legal profession.